Please, Pallavi, you can now start.
Yeah.
And yeah,
It
and
is.
please send me the link.
It's there in the chat, sir.
Okay. Oh, let me कैसे जाए? Thank you. So, Lakshmi, you can begin, please. Thank you.
Okay, sir. Thank you, sir. Hello everyone. Welcome to the webinar titled RTI Opportunities and Challenges in Indian Context. I am Lakshmi Walia, final year law student of Law Center 2 and I'm interning under Mr. Sanjay K Chadha, BSK Legal. I'll be your host for the meeting today. BSK Legal, amidst this pandemic situation, has been disseminating a lot of information amongst the masses and providing great opportunities to the students. Thank you, sir, for that. And there are a lot of individuals joining at the moment. So I'll first give a brief about the guidelines to help in this webinar. So first, please make sure your mics are muted throughout the session and unmute when asked to. We want to make the session interactive, so everyone is requested to switch on their videos. And in order to get a certificate for this webinar, you are supposed to take a screenshot and share with us. And question and answer session will be after the discussion. You can write the question in the chat box, and we will try our best to address all the relevant questions. For people who have just joined, we will mention the guidelines later. Coming back to the topic, RTI has been extensively used by citizens of India. Being law students, we should be aware of the nitty-gritties of the RTI. In today's session, apart from having a basic view of RTI, we will also discuss the challenges faced at ground level. To discuss this, we have two prominent resource persons with us, Mr. Sanjay K Chadha, founding and managing partner at BSK Legal. Sir has immense experience in civil and commercial disputes, matters relating to labor and employment laws, consumer protection, commercial criminal arbitrations, and he has represented the cases at Supreme Court and various district high courts. So is also looking after labor and allied law compliances for many clients, including India's largest private sector life and general insurance companies, ICICI, Prudential, and Lombard, to name some. And our special guest for today is career bureaucrat, Mr. Pankaj K.S. Shreyaskar. Sir has worked as Joint Secretary and Additional Registrar of CIC. He is presenting the Director of Ministry of Program and Implementation. Sir is recognized by Department of Personnel and Training as one of the most eminent speakers on RTI. Sir has also authored two books titled Combat Corruption in India and RTI Act in India, Features and Implications. I'm delighted to have this opportunity to learn from our eminent speakers. Over to you, Sanjay sir. Thank you.
Thank you very much, Lakshmi. You've been always a strength to this group. And I also would like to mention here three of our partners who have really worked day and night to make this success. And later on, Rini will speak about them at the end. Rini is also a big asset to us. And also, all of you are, I would say, a big asset to this nation as such. So today we have very eminent guest with us, Shri Pankaj Pandeji. I call him as, and I'm very happy to have Mr. KVJ Rao, who is also joined us. Mr. Rao, taken out time. I could see you. Thank you very much, sir, for coming. And such would always make all of us excited, and it gives us energy. Thank you very much, Mr. Rao. I will begin with with RTI, and I will take up little a kind of because most of my listeners today, most of the attendees today in this webinar, which in Zoom itself we are full now, and here I could see we are over 100 here also in YouTube. So basically RTI is one of the, as I say always, is one of the most important litigations of near last 2-3 decades, if I may say so. One of the most important, and it has given energy, power to the masses as such. Basically, it has, if I may say so, uh, it has given a practical regime of information, right to information, which to each of the citizens, basically to secure access to the any of the information which is lying in the public regime with the public authority. The three keywords which are very, very important: transparency, accountability, and uh, and as Pankaj ji always says, pardarshita. That's always it reminds me whenever I use this word. So in the working of public authorities, as we all know that we are the biggest democracy of the world, we are the and such laws are basically. Oh, I'm sorry, I would stop here for a minute. One of the professor of Delhi University has just messaged me that she cannot enter. Urmil Vats, if you could just take her in, if possible. Otherwise, I don't know. I mean, I will continue again. She wanted to join us. She is a professor in Delhi University. She has sent me, but as our room is already full, I don't think we will be able to. I'm sorry. So, as I said, I was on the point that we are the biggest democracy of the world, and one of the key element for a successful democracy would be anytime an informed citizen. If a person is informed, he'll be able to contribute in a best possible manner. That's what I feel. The RTI has certainly curtailed lot of corruption. There's no doubt about it. For any information, we used to, to quicken the excess, we used to go back to the corruption, and we used to pay money to these people for the information. So that is one thing, the biggest advantage. Then other advantages, if I may say, that it gives a power to the individual citizen, so that democracy works at the citizen level. Even a smaller person has the power. In real sense, if we need the democracy, I would say the more accountability of government, I would say more accountability of uh, 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 um, not only each and every limb of the government is now more accountable. And it reminds me of a very recent judgment of Honorable Supreme Court, wherein Supreme Court has said that even the office of CJI, Chief Justice of India, is very much covered within the ambit of RTI. That means if you need any information pertaining to the judges, you can very well approach under under RTI. I would say that this is one of the most important laws, as I said in the beginning. Now, I would like to, for 2 minutes, I would like to tell you what are the important provisions, how it has strengthened, because many of the law students are also here. So the majority of the viewers today are law students. So 2-3 provisions which I will quickly say, and then I would certainly go back to my friend Pankaj, who will tell us various dimensions and a lot of questions we have, which we'll put in to him, as well as wherever, if my access is needed, I will also be there. The first and most important, we all know that RTI Act was passed in 2005. The most important provision is that here you are bound to get, it is obligatory on the part of the person whom you have asked for the information to respond to your query within a fixed time, that is 30 days. And one most important thing, when there is a question pertaining to liberty, personal liberty of any individual, that time comes down to just 48 hours. Within 48 hours, the authority, public authority, has to respond to you. And now the very interesting thing is this, that if you don't get your reply within the time as defined in section 7, then you have all rights to go to the appellant at state level, at national level. You can very well go in for an appeal. You don't get reply, it is presumed that the reply is denied to you if it doesn't reach us within 30 days. So such a dynamism. Otherwise, if this kind of provision would not have been there, that means you keep on waiting. So that is one thing that the lawmakers, legislature makers were having this clear in their mind, that this kind of problem will be there. So you can very well go for an appeal. And not only this, as I said, if you have a right, the person who is the public authority has a correlated duty as well, obligation on the part of the public authority. If they don't furnish the information within the defined time, then what will happen? There is a provision, and that provision is a very, very relevant provision. That is provision section I think 20, section number 20, which says that there is a provision of penalty on that particular officer if he doesn't provide you the information within the provided time frame. He has to bear penalty rupees 250 per day, and that goes to the 25,000. Yes, Mr. Rao is saying 25,000. So that is what makes this particular particular act a very dynamic act, and it has certainly, I would say, has given lot power to the citizens. It is open for citizens only. This law is applicable to the citizens only. Only right to information is available to the citizen of India. So this is a very dynamic law. And now this is what a gist of the law which I wanted to give to all of you. And now I would request my honorable guest, Pankaj P.K. Shreyaskar, also known as Pankaj Pandeji, to come. And
sorry if I may interrupt for just 1 minute. I'd
please
like to mention that all Zoom attendees will get a certificate. All that you need to do is take a screenshot of yourself attending the Zoom meeting and give that to us in a Google form that we will circulate after the meeting. So you need to take a screenshot of your attending Zoom. Thank you.
So I would now request my guest to please come and take this meeting, and the munch is yours now. Thank you very much, Pankaj, once again.
Thank you, Chadha-ji. Thank you so very much. And first of all, good afternoon to everybody. As very succinctly, introduced by Mr. Chadha, the subject, of course, we will have further details on this subject matter. But I would also like to comment certain things about myself, what Mr. Chadha was saying, that he had mentioned that I'm very good at heart. So it will be very difficult for me for another 1.5 hours to, prove that I'm really good at heart. Let me do that if I can. Now, coming back to the legislation. It goes without saying that it is one of the most important legislations of the post-independence era. Why? Because of the fact that the strength of the law, the strength of the power, to my mind, has been first time realized by a common man walking down the streets, wherein they are asking, a rickshaw puller is asking the IIT Kanpur that, will you please let me know what is your research funding for the last 2 years? One of the persons working there in my village is asking the block development officer as to, would you please let me know as to when did you construct this approach road going back to my village? Uh, it's not about necessarily to have the answers of all the questions. What is really important to raise the questions. And I was pretty keen as a small child in a class was to realize that raising a question is extremely difficult art. Answering a question is not as much difficult as to raise the question. So to that extent, to my mind, RTI is indeed, it has actually changed the way the governance is undertaken for the last almost more than, a decade, that is around 15 long years. 12th October 2005, this act came to the force. Before we go into the provisions of the law, let me quote from Bhagavad Gita. It is apparently a rhetoric, but I would do that, is that it says that the truth about the action must be known. Truth about the inaction must be known. Truth about the prohibited action also must be known. Mysterious are the ways of the action. Now, to my mind, nothing better than this Srimad Bhagavad Gita's Shlok 17 in chapter number 4 explains the Right to Information Act than what I could see there in Bhagavad Gita. Now, let's understand as to why do you need to have such a legislation in place. As has been mentioned in these slokas, as I said, mysterious are the ways of the action. That means we have limited resources. Within the limited resources, you have to attend to many of the demands. So it's a question of demand and supply. So certainly you will have to take, apply your due diligence, and subjectivity will come into vogue. Since subjectivity comes, somebody else will be hurt. So in the legal terminology, you are actually, as an administrator, deciding a list. Now, if you decide a list, you're certainly going to affect the others. So since you are going to affect the others, he will not be, happy. He will not be satisfied with the manner in which you have acted in a particular situation. Therefore, I would question you. Since I will question you, you are bound to answer me as a good democratic institution, in a country. In 2005, October, this became truth kind of things, that it came down in a systemic formats, and it was given into the hands of the people. On the other hand, there are certain issues also which are coming. For example, look at the look at the inequality sort of things. Merely because you are a part of the public institution, you are made accountable through various means, whether it is a Right to Information Act, whether it is Lokayukt, whether it is Whistleblowers Act, whether it is many more in pipelines. On the other hand, there are private sectors which is not so much accountable as they should be. And at many occasions, what happens that through the use of this RTI instrument, the private sector also keeps hold of this information and makes use it for their commercial interest, for their many other interests. Well, I'm not saying this. These are certain arguments which keeps on coming, and an argumentative intellectual questions raised is that, is this a common field given to the private sector and to the public sector? Now, this is a conundrum. This is a conundrum which you need to answer. But the answer lies in the fact that since you are a part of the public institution, you are bound to be answerable to the citizens of this country. And therefore, prima facie, this argument that the private sector also should be made equally accountable, is set aside insofar as the Right to Information Act is concerned. And the way we progress, we will see that you just name one of the private sectors, and I will tell you that there are regulators in this sector as well. And you may not directly file an RTI with the private sector, but through the regulators, you can indeed make them accountable, at least to the point of the supply of the information. That's the power of the law. That's the power of the law. Now let's go back to certain principles which are mentioned here. The transparency is one of the very, very important touchstone of this Right to Information Act. And when you talk of you becoming transparent, what are actually you are trying to do? You are trying to say, look, this is the decision which I have taken, and these are the principles of decision making, and that you should know. The question arises, therefore, is merely supply of information is a guarantee that there will be a good governance in any system? Well, I don't know whether is this a guarantee or it is not. But yes, without basic information, you would not even know what to question. You would not even know what to audit. You would not even know what to suspect. So therefore, information is indeed extremely important parameters of the entire decision-making processes. Also, that there is yet another touchstone of the law is what is called practical regime, as Mr. Chadha had introduced this concept. Now, what is a practical regime? Practical regime has many facets to realize. One of it could be that you have given me a right, but does it remain back into the books, or is it coming down to the ground? Do I have to prove something that, look, I'm a literate man, I can speak English, and therefore, I have a tie, and still I am under below poverty line. So do I have to prove these parameters to file an RTI application? This is one aspect. On the other hand, I'm a public representative. I'm a public servant. Do I have to seek permission of the government to file an RTI application? In both these situations, answer is in negation. That no, I need not answer. I need not take any permission from the institution that I wish to file an RTI application against yourself. Or on the other hand, I need not even to be a literate man. The beauty of this law is that I would just go to your office, will ask you to write an application yourself because I'm an illiterate man, and you will have to assist me because I'm an illiterate man, and I will ask you to draft an application against yourself. That's the spirit of this law. That's the strength of this law. The third important point, which is available in the preamble to the law, is what is called balancing of the disclosure vis-a-vis sensitivity of the information. I would not use the word privacy because that I am keeping it for another 10-15 minutes later that I'll take it up. But that's one of the greatest challenge that RTI has to face in the coming years to be in line, is that privacy so far was not part of our constitutional right. But now that it has become part of the constitutional right, what will happen to the Right to Information Act? That, of course, is a challenge which we'll have to see as to how does this unfolds. But the sensitivity of the information, it talks about balancing the sensitivity of the information. Meaning thereby, let me draw a line. Transparency is all right. How far should you become transparent? Should this call for a transparency become nudity? Should everything be made public? Now, that's the question that you need to answer while taking a decision. Should this information be made available to the public, or should it not? In this case, you must weigh. And what you may weigh is that whether on the cost of disclosure of the information, are you actually disclosing or challenging the sensitivity of the information? Somebody's whose information is so critical that disclosure of that information is going to result into certain social banishment and many more social parameters, attached to that. But while doing this, there are certain limitations in this law. And this I'm speaking as a common man of this country. This I'm speaking as a researcher, because you have to be extremely careful being a part of the government. So this I'm speaking in my personal capacity, is that there are certain loopholes in the law. Is that it also talks of that come what may, if the larger public interest demands disclosure of the information, you must disclose. But no parameters has been mentioned in this law as to what would identify the larger public interest. It is which element, which will help me to tell that yes, there is a larger public interest and therefore we must disclose. Then you also have to always make a contradistinction between the personal privacy and the public interest. So how far should you allow the public interest to intervene into the privacy of an individual? So these are the questions which are actually critical in the years to come. For example, you see, way back, there was a French philosopher, Foucault, who had said that in the years to come, the governance of a country would be run not through by the military power, but by the biopower. And Aadhaar is one of the classical examples of, biopower. So the public institution have all the information available with Aadhaar about our iris, about our personal issues. Now, question is, I file an RTI with UIDAI, and I wanted to know about certain details inclusive in the Aadhaar document in relation to, say, Mr. Sanjay Chadha. What should the public authority decide? Should it be disclosed? Should it not? Then you also have to look into the legislature's intent. Legislature's intent is to make a balance of disclosure. As I said, you also have to protect the sensitivity of the information. For example, way back, there was an Armed Force Medical College hospital, and therein a husband, which was not known to be a husband until an RTI application came to the matter of an appeal before the Central Commission, was that an RTI application was filed to know as to what kind of test was conducted on his baby while his wife was delivering a child. Now look at these questions. Should the doctor disclose this? Should he not? Alternatively, the beauty of this law is that I, as the information provider, have no right to ask as to why do you need this information. For example, I mean to say that in this law, you need not prove as a citizen of the country your locus standi. I don't bother to tell you why do I need this information. I will take this information, coming out of your room, I will tear it off, throw it in dustbin, but you are still accountable. You have to answer. Let me also share with you my experience that a kind of information that has gone in public domain, either through proactive measures or through the invocation of this RTI application to the public authorities. Let me remind you, not more than 2% of that information which has gone to the public has been made use by the citizens of the country by and large to improve upon the system. Now, these are issues which we need to think quite intensely, so as to bring about systemic change in the years to come. Also, that it is debated that at the middle management level in the public institution, the impact of RTI Act is, very, very powerful. But people also say that whether RTI Act has indeed made a dent at the higher echelons of decision-making processes is a question which I will leave open for you youngsters to think. But let me give you certain success stories of these RTI Act. 2009, early 2010, the conduction of the IIT examination, IIM's examination was given to what is called Prometric Center. And they were conducting examination for Indian Institute of Management, CAT examination. And what had happened that an application was filed before the CPIO, the terminology which is used, the person, a single window system in a public authority, who will receive the application in IIM, to know as to what was the model answer sheet of the questions that was given out to the students. And the answer which was given is that this record is not held by them. So as a result, the matter came back to the commission, and commission passed an kind of recommendation as also a little bit of order, saying that, look, to bring about the credibility to your institution, as powerful, as respectful as IITs and IIMs. You can't remain a prisoner of the past. You will have to prove at every step of your functioning that, look, you are credible. You are credible for the fact that the day examination is over, next day model answer sheet is placed in public domain. And once the results are declared, give the students 15 days time to check up whether they have their awards are exactly in line with what has been placed through the answer sheet in the model answer sheet. And then let them give time to represent back to the institution that, look, I should have scored X, but you have only given me Y. And then you correct those anomalies, and then again you start back your admission processes. Thanks to RTI, that since 2010 onwards, and IITs, after the examination, their model answer sheets are placed in public domain. It was us, I mean, while I was serving with the Central Information Commission, that we said that you please allow the students to go onto the website, put their ID and password. ID could be the mobile number, password could be his email ID, and so on and so forth. Let them allow to access their OCMR sheet and then audit themselves as to how much did they score qua their model answer sheets, which are available in public domain, and it is doing pretty well. Another example which was given by Mr. Chadha was that way back in 2009, an RTI application was filed with the Public Information Officer of the Honorable Supreme Court of India, asking only very limited sort of questions. And it was when Honorable Mr. Justice J.S. Verma was the Chief Justice of India, there was a decision taken that the assets will be it will be declared on a piece of paper by honorable judges, and it will be handed over to the Chief Justice of India. And the question which was asked through RTI was very limited as to whether that resolution which was passed by the full honorable court has been complied. The answer could have been given yes or no. Then second question was that if yes, how many of honorable Mr. Justices have so far not complied upon the resolution? Only two simple questions. And then it could not have been answered by the registry. And the matter went up to the Central Commission. And the Central Commission simply passed an order saying that, look, the question here which is there is that whether Honorable Supreme Court of India is a public authority or it is not. If it is a public authority, the provisions of the law will apply. If it is not, then it's a different treatment altogether. Now, the question arises, a legal mind will start thinking, is that the Honorable Supreme Court is a constitutional body, and the Central Commission is a statutory body. Now, can a statutory body pass an order to a constitutional body? I recall what is called child is the father of the man. And even though statute gets its strength from the Constitution, but within its four walls, whatever rights have been given of these 15-page document, which is Right to Information Act, we passed an order. And first time I saw that the registry of the Supreme Court, after having the CICs passing this order, registry of the Supreme Court filed a writ before High Court of Delhi, challenging our decisions passed by the Central Information Commission. It's altogether a different story that a single bench, the division bench, and the full bench of the Honorable High Court had, upheld the decisions passed by the Central Information Commission, and finally the matter went up to Honorable Supreme Court, and a very happier to see that Honorable Supreme Court also agreed with the decision passed by the Commission. So
I would just like to jump in here, and would like to give you a very interesting thing. Please permit me. I'm sorry I'm interfering because it's a legal question. Then, as Mr. Pankaj said, that it was challenged before the Supreme Court, and Supreme Court initially 3 judges bench. Two points I want to say here. One, that it is very rare that in front of Supreme Court has challenged its own judgment. So Registrar of Supreme Court has challenged, the name of the case is Registrar Supreme Court versus so-and-so. So that Subhash Chandra Agrawal, if I'm not wrong. That is one thing. Supreme Court challenging an order of High Court in Supreme Court itself. One aspect. And second important thing, which Pankaj ji has just mentioned, that initially this case was handled by 3 judges. I want to just give this information to all my law students as well as the other people who are sitting here, that initially it was 3 judges benches, and in the first hearing itself they have stayed the order of the Honorable Delhi High Court, and thereafter they referred this matter to 5 judges bench judgment. So it's a very, very important judgment, and I may say that the court has said that RTI as well as right to privacy, which is 9 judges bench judgment, are 2 sides of right to information and right to privacy. Both are 2 sides of a coin. So that's kind of wonderful interpretation our Supreme Court has given. Thank you, Pankaj. Please continue.
Thank you, and I must, congratulate Mr. Sanjay Chadha, is that his seeking permission to intervene is tremendous. First he intervenes and then seeks permission. But anyway, great. That's the beauty of becoming a lawyer.
The best part is that I have got the privilege here, because I always feel that I'm your senior. So that advantage I will also always keep.
Yes, I was inclined to make these kind of small statements just to keep all of us awake, and just to ensure that it does not become a mechanical talk, but it also excites you. It prepares you for the questions that you must reserve even for today. You may not, if not, you can raise today, you can raise it at some other forum. Now, come back to the provisions. The first and foremost, and while taking the provisions, I will keep on raising the issues of the challenges, the issues of the furtherance that you must work upon to ensure that it becomes clear for everybody to understand. For example, it says that the provisions of the law is left open to citizens of the country. Now, this is one of the greatest challenge in the years to come, I tell you. Assume there was this judgment of Honorable High Court of Punjab and Chandigarh against what is called Union of India versus Fruit Merchants case passed by Honorable High Court of Punjab and Chandigarh, Punjab and Haryana. And you know what it says? That henceforth, and that judgment was served upon to the Government of India, to the Central Information Commission, with an intent to ensure that in future these directions are made, must be followed. And what it says that the public information officer, who is the single window in a public authority to whom an RTI application would be addressed, he has to produce by a citizen a proof of his identity. Now, it's very tricky. Let's suppose if I'm a public information officer, I receive an RTI application from a student studying in class 8th in Sitapur village, which is a district in UP. And she studies in one of the primary schools of the village, which does not provide any identity card to the students, and which is not a surprise. We ourselves, let me share it with you, that if you ask Mr. Shreyaskar, do you have your birth certificate? Answer is no, I don't have. So it's not a big deal that a student studying in class 8th in Sitapur does not have any identity card. But she wants to file an RTI application for the reasons that she is made to sit on the floor despite having made lots of announcement that now computer has come to the school. They are made to sit on the desk and the smart computers on a chair and so on and so forth. She files an RTI application to the principal of the school, wanted to know how many desks and chairs have been purchased in last a year or two or whatever. And the principal of the school says, or for that matter, I twist the question and I say that the student files an RTI application which what is called district education officer. And the district education officer says that you produce your identity before I proceed with this RTI application. Tell me, what identity proof should I produce? From where do I take it? This is one of the greatest challenge. Second, I'm raising questions for all of us to understand. This is open. This Right to Information Act is open to the citizens of the country. Now, tell me, if I were to ask you to produce a document which will prove that you are a citizen of the country, what document will you produce? What document proves that I'm a citizen of the country? Is it the voter's identity card? Is it the passport? Of course, mind it, how many of us will have a passport in our people staying in the rural India? Even if that is so, the passport is not made on Citizenship Act. It is made on the Passport Act of 1961. What is that document which will prove that I'm a citizen of the country? I leave this question for you all to think. And you know what? Today's webinar should prepare you to take up at least one of the papers that you must write for one of the journals. Raise these fundamental questions. And so, for example, as a PIO, if I receive an RTI application from Sanjay Chadha, how do I decide? Should I ask him whether he's a citizen of the country or not? Should merely on this ground I dismiss his application that he is not a citizen of the country and therefore I refuse? Mind it, before the Central Commission in appeal, the PIO has to prove that he has acted in due diligence and in consonance with the provisions of the law. How would I prove, or how would I say that it was for this reason that I asked Mr. Chadha to produce a document so that I can satisfy myself that he's a citizen of the country? I don't know. What should be the parameter? But it is well within the law that CPIO prima facie may reject an application saying that produce before me stating that you're a citizen of the country. I raise another question. This is, because you are all legal prodigies, if I may say, or in the process to become legal prodigy, you must. Is that, let's suppose, a person who is behind bars in Tihar jail. And why I am giving you this example, this is not a hypothecation. This is what has actually happened. Is that a person, he is behind bars in Tihar, and he wants to file an RTI application. He does not have money because he's behind bars. He does not have money to pay fee for filing an RTI application. I'm just raising an issue a priori. Thereafter, I will go with the provisions of the law so that you'll be able to appreciate. Is that, you know what? I am behind bars. I don't have money. How will I purchase a postal order? So the practical difficulty for a person to file an RTI application who is behind bars are two. Can I question, is he a citizen of the country? Second, how will he submit the fee for filing an RTI application? So my only plain raising issue to this provision is that we have to be extremely careful in this country to understand merely because one statement is made that provisions of this law is open to the citizens of the country. This itself is a big, big ocean to ponder as to who are citizens of the country and who all can file these applications and how should they all be treated. Then let's go ahead and am I making sense or do you think that I should go specifically into each of the provisions? I'm just picking up certain threads and then introducing those concepts, and then later on you can see. You know what? The terminology which is used here is the public information officer. That an officer who is representing the public authority, and it is a single window system. So a citizen of the country would not know as to whom should I file an application. He need not know. He should simply write Public Information Officer, Ministry of HRD, Government of India, New Delhi. That is it. You can file an RTI application. I recall when I was in CIC, suddenly at around 4 o'clock in the evening on one of the working days, I got a phone call saying that, is this Central Information Commission? I said, yes, it is. He says that I'm calling from Karnataka. Will you please be able to tell me from which platform number today Rajdhani Express to Bangalore is leaving? I was completely stunned. I said, are you sure that you have, phoned at a right place? He said, yes, indeed, I know. I have you are an RTI commission and you have to answer me as to from which platform was it going. On the other hand, I got a application. Please understand the challenges. Somebody asked me, I will not name that. Why? Because, these days he is sitting at a very important position in Delhi. Somebody asked me in CIC 2 questions. A, are the information commissioners supposed to meet the citizens of the country? B, is India still not independent? Now, look at the beauty of the questions. Trying to respond this question under RTI Act by a public institution, it is extremely difficult to answer. Because if you say, RTI Act essentially talks about providing information which is a matter of record. That means something which is generally known to us, which is an axiomatic truth, may not be within the four walls of RTI Act. This has to be recorded under certain document which is held by the public authority. Now, when you say that it is held by a public authority, the superior courts have given interpretation that holding a public authority must be exclusive. That means, for example, somebody filed an RTI application in the commission wanting to have a copy of the Right to Information Act itself. Now, question is the Central Information Commission exclusive holder of RTI Act? Mind it, this is available in public domain. It is available in bookshops. And the Central Commission itself, downloads this, purchases it, or receives it from the appropriate government. Can you deny this information to the citizen of the country, saying that, can you afford to make a statement that, look, the Central Information Commission does not hold this information? It's a tricky task to respond. So the RTI Act actually identifies a single window system, public information officer, irrespective of his name, address, designation, nothing. And you simply mention it and you send the RTI application with a fee of ₹10 if it is a central government public authorities. Now, again, I raise before you the problems of this whole RTI regime is that the word which is used is the appropriate government and competent authorities. Now, appropriate government, you understand, it has been defined in this law as well. And the competent authorities have also been defined. For example, all the chief justices of the high courts are the competent authority. Chief Justice of India is a competent authority. Administrator, in case of the UT, is a competent authority. And, these are the competent authorities. Appropriate government, the central government, the state government, and the local government. Now, you would realize that in RTI Act, there are, as on date, 88 rules, all encompassing the competent authorities and the appropriate government. So 88 rules are there in vogue. And if you want to file an RTI application, you can't have a single, simple solution. That's another challenge that you must be aware of. For example, some of the honorable high courts in recent past had prepared a format of filing an RTI application wherein you must give the passport size photograph. Act does not demand anything of this type. It necessarily says a person who is desirous to seek information must file an application with the public authority, right? And he need not share anything except the address on which he must get his response. That is it. Also, that let me share it with you, till 2006, as I was given to understand, is that High Court of Delhi were not putting in public domain the cause list. And it was sometimes in late 2006, early 2007, that the matter came before the commission. And then we recommended the public institution, the High Court of Delhi, to please place these cause list in public domain. So
almost
then
all the courts, even not only just informing, not only the cause list, but even to the extent all the orders, cause lists, everything are online from district to Supreme Court, district courts to Supreme Court, High Court, District Court, Supreme Court, all are now become online.
Yeah,
and
sure.
Especially in this period of Corona, this has become more online. E-filing, everything is developing very, very fast.
No, that's perfectly all right. These are the outcome of a crisis period. And thanks to Corona, that perhaps the rest of the work which RTI has not been able to do, Corona has perhaps done. So that's a different story altogether. But I was referring to an era.
2006 you were talking about.
Yeah. You know what? So these are the issues which was brought before to the commission, and we are really proud to have contributed through these RTI institution certain changes that we thought are essential for the good governance. Let's talk of information. What is information? Essentially, information means almost everything which a public authority holds. I mean, which is available with them in material form. So material form is a must. And you know what? It also says that blah, 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 blah is information, and all other details are also information which is not held by public authority, but is held by any private body which can be accessed by that public authority under any other law for the time being in force. Now I raise an issue of, I'm sure you all must be aware that each of the schools or the private hospitals, they have to keep certain seats reserved for the economically weaker section of society. Now, can you imagine DPS RK Puram? A lady who is staying in Jhuggi and Jhopri colony wanted to let her children study in DPS school, RK Puram. She knocks the door and wants an application form because she wanted to file, file an application request with the DPS school under the economically weaker section of society. I'm afraid that it will be possible. But every year, schools like DPS, it is just an example, nothing specific, just an example. All such private hi-fi schools files their report to the Directorate of Education in Delhi that this year, these are the 20% of the students who have been admitted under economically weaker section of society. It is here, because of RTI, that people like you can examine what is called social audit. You bring in through RTI what is called social audit. You seek this information, go back to these places in, those South Delhi Jhuggis, and get this information as to who these Payal, Priya, Mona, Sona are studying in DPS school through the economically weaker section of society. Check them. Are they indeed studying in these schools? So these are the RTI Act, therefore, to my mind, is also one of the greatest instruments of social audit, which is just instrumental in India. It has so far not become so popular. And for the youngsters like us, no, I'm not keeping myself away from becoming young. I'm leaving Chadha ji out. So, so that's what I'm saying, that you should keep on doing social audit through these RTI applications. But mind it, the essence of information has to be material evidence, which are available on record. So therefore, I also give it another treatment. That means RTI is all about something which has happened in past. You should not actually manifest your questions, which is futuristic, which has so far not taken place, because it will be very easy for the information providers to say what you have sought for is not available on record. Therefore, it is not an information. So your application is non-est. Right. So therefore, essentially, so therefore, raising a question with the public authority is an art. What should you ask? How should you ask? Keeping in view that by default, you are going to get a response, no. I guarantee you, however, that you would indeed get a response within 30 days. I guarantee you. But what kind of response will you get will depend on what kind of question do you raise. And therefore, you must raise questions which are possibly available on records, or something which has happened, and also that it has certain documents to be with you so as to prove the veracity of the your own statement which you are relying. So the public information officer is essentially a single window system of the public authority, and information is almost everything held by that public authority. And then it also talks of who all are public authority. Where all can you file an RTI application? You can essentially file an application in this country with almost everybody. See, all government institutions are public authority. All banking sectors are public authority. Let's talk of the private sector. How should you approach them? The private sector, for example, ICICI Bank, all such banks. What do? ICICI Bank per se is not a public authority because they have not been constituted by the Constitution of India or by any orders of the government of India and so on and so forth. So therefore, what do? I go to the Reserve Bank of India, which is a regulator of these banking sector. And you know what? Go back to the definition of information, which says that, and all such information which is held by a private body, under any other law for the time being enforced. So I invoke RBI Act, and I also invoke Banking Regulation of 1935. And then I file an application with the Reserve Bank of India, and I tell Reserve Bank of India, refer to this provisions of the law under which you are authorized to access this information from private body. So you do that and pass it on to me. So by RTI, you are actually necessitating the regulators to act in a particular manner that they should do actually. Though it is again a challenging issue, is that assume certain set of information which RBI should have taken from the private banks in 2019, they did not take. But you wanted to seek this information in 2020 by filing an RTI with the Reserve Bank of India, and they respond that they do not have this information because they have not accessed this information in 2019 from the private bank. Now, question is, the challenge is, should the RBI now, while you have acted as a catalyst for their being, not on toes of seeking this information by the RBI, should they, after your filing RTI application, access this information from the private body and pass it on to you? So is it not something that you are necessitating the Reserve Bank of India to function in a particular manner? I knew that you did not function in this manner, therefore I filed this RTI application. And you know what? The supply side of the information, which is the public authority, and the demand side of the information, which is the citizen of this country, they are actually not adversaries, mind it, but both of them are making their own strategies, and there is nothing wrong in this. And what is called in mathematical terminologies, these strategies are called two-person zero-sum game. So there is nothing wrong if the public authority is not responding to you straight because he wants to defend himself. And the art of your becoming a good citizen is to keep on following as many RTI applications as possible to expose him because his strategies were not confounded in the records. So therefore, and there is no bar on how many applications can you file in an RTI application by paying 10 rupees fee in the central government. But as a common man of this country, we must be accountable, responsible, and only should raise legitimate questions which can still hold this RTI very, very serious instrument of governmentalities. And you should not keep on asking. I recall Honorable Mr. Justice CJI, former CJI, I forgot his name. He had written an article in one of the journals who he says that I have great respect for RTI, but in the recent past, the kind of superficial, kind of superfluous questions that is being asked is that is making it weaker. For example, he was called by one of the bar associations somewhere in Andhra Pradesh, and an RTI application was filed. Was he called by the bar? Did he take coffee? Did he take tea? Did he go by this? Did he go by that? So these are the questions if citizens keeps on asking, will make this law more serious. I mean, less serious. These were the public authorities. So as I said, almost every regulator will take care of the private body. You only have to be quite, sensible in raising the question. I give you another example. Is that Delhi has a power supply company. They are BSES, Rajdhani, and Yamuna, and then Transco Limited, and so on and so forth. Assume that you are getting a huge mammoth bills, and if you are wanting to go back to them, there is nobody to help you. Now what do? Because BSES Yamuna, BSES Rajdhani, these are private bodies, so you can't file an RTA application with them. So what do? You file an RTA application to the regulators, which are Delhi Electricity Regulatory Commission. They are one of the public authorities. So I file an RTA application with them. And let me share with you that way back in 2011, an RTA application was filed with the DARC asking to know as to what are the parameters based on which the unit cost of electricity consumptions are decided. And way back in 2011, Central Information Commission has declared all these three DISCOMs as a public authority. Now, I'm speaking as a common man. Despite 9 years have gone by, the matter is still pending before the court of law, whether they are indeed a public authority or they are not. Incidentally, I had authored an article which is available in Economic and Political Weekly, which says, I have said that known unknowns of RTI Act, legitimate exemptions or conscious secrecy. So you may like to go through, I have cited certain cases, and how does the common man is actually again in a quandary rather. If he goes back to the DISCOMs, they say that the matter is pending before the court of law, and we have so far not been declared a public authority. The fellow comes back to the commission. Commission says that we have already declared them a public authority. The matter is pending before the court of law. Where do I go and file an RTI? So to that person, to that public authority, the right of that citizen becomes constrained because there are dead end. So these are certain challenges that this law is actually throwing. Now I come back to, there are two provisions in the law. One provision is, Mr. Chadha, you may like to tell me as to when should I stop by giving me at least 10 minutes time so that I leave the floor open.
I will just say one more thing, that you had mentioned the example of the order passed by the CIC 9 years back, and the same is challenged. Now, what I wanted to tell you, the answer from the legal perspective, legal point is that the situation is still fluid, and once the judgment comes, this will become a strong. They have all rights to. They have challenged the order under their own rights.
Sure.
The only problem which we are facing here is that why this is taking so much time. So what the person who are engaged in it should have done is that they should file a early hearing application for those appeals, and it will be soon be decided.
No. Fair enough. I was just trying to mention that each one of
these are the hard. Look, everywhere such a major event has happened in democracy of this country. We have to appreciate, as you said, that it is a milestone of, in centuries such thing happens. Such a big event has happened. And this is what has made our democracy so transparent, accountable, so strong, what I feel, because it gives power to the single citizen. Now, as far as you had asked me how much time, so you can speak for another 10 minutes then, because a lot of nice questions have come. And we have with us Mr. Inderpal from MEPSC. So he has also asked one question, which I would put into you. And so many other questions have come.
Sure.
We'll together give answers to those questions.
Okay.
Thank you. Another 7 minutes you can very well speak. 10 minutes also.
You know what? The two important elements of this law is, one is mentioned under Section 4, which we call it as a proactive disclosure. And there is section 6, which authorizes a common man to file an RTI application with the public authority. So section 4, which is a proactive disclosure by the public authority, to my mind, is the mind of the law. And section 6, through which an application is filed before the public authority, is the heart of the law. So heart and mind must be in conjunction for the public authority to prove that they are actually a great votary of good governance. So let's see what section 4, which is the proactive disclosure, should they all tell you. So you know what? This law also says that more and more information should keep on coming in public domain proactively, so that people has to resort less for filing an RTI application. And in 2010, Central Commission had passed an order to all the public authorities to say that let's prepare what is called dichotomize the class of information that you hold. You, on one hand, you call them a positive class of information. On the other hand, you call them a negative class of information. And this positive class of information and the negative class of information will keep on changing and will remain dynamic. That means something which is a positive class of information, you need not file an RTI. If something which is available in public domain, why will I file an RTI with you? And you please also say a priori through public domain that so far as on date, these class of information are not disclosable insofar as we are concerned. Obviously, that will be put to the test of the law. And if it passes the scrutiny of the test, that will remain in negative list. Else it will come back to the positive list, and you will continue churning the various class of information coming from the negative list to the positive list. And that's the success of the RTI Act. So as I said, section 4, which is the proactive disclosure, is the mind is the mind of the law. Section 6, through which I file an RTI application, is the heart of the law. And as I said, the citizens need not answer why is he seeking this information. But he should only be aware that if he is asking the information, should it remain in, some material form. Now, question is, how would I know? How would I know as to what records do you keep in a public authority? Let me very honestly share with you, working for the government of India for the last 2 decades, I'm not sure if I can say as to how many agencies are there in government, and all of them, what do they do? To be very honest with you, I perhaps may not be in a position to tell you how many agencies are there. While preparing annual report for the Central Commission, I had recorded there that there were those days in 2014, last the Central Public Commission's annual report, there were around 6,000 public authorities registered with them. So there are many more which we do not even know whether they are reporting, they are not. So the question arises is that if they are such a huge public authority, what are they doing? Unless I know that what they do, how will I ask a question? So it is there that they must declare suo motu what all they do. What are their norms of decision making? Classical response that you will see on the website of the public authorities would be something like this. The norms of decision making are as decided by the government of India from time to time, neither here nor there. So these are certain more explications that must be made out. When you say norms, you must apply the management principles of norms. And therefore, you would know that we have been hearing for the last so many years that within 2 days, your passport will be delivered back to your place. Should you not, a priori said that, look, the principles of good governance is this, that a student or a person who files an application for issuance of a new passport must have these documents. If all of them are made available as desired, the passport would indeed be delivered in 3 days. This is called commitment towards good governance. So that opportunity you get in RTI Act. Now let's very quickly touch upon, is it everything about disclosure? No, it is a balancing of disclosure and non-disclosure of sensitive information. So there are 10 broad clauses, which to my mind broadly encompasses almost all possible situations which you can bring in under this if you do not wish to declare this information public. To begin with, first and foremost is the national security. So when you talk of a national security, there is a usual feeling that national security must necessarily be used by some of the security keeping agencies, but that's not the fact. While you go deeper, you would realize that national security is not only limited to the military security, is not only limited to defense security. It can also now be extended to what is called the economic security of the state. It can also be extended to what is called the cyber security of the state. It can also be extended to the strategic security of the state. So initially we thought that such exemptions must be exhibited by the Ministry of Home Affairs, Ministry of Defense, and similar agencies. But later we realized that no, there are Ministry of Finance as well who can say that disclosure of this information is going to compromise with the national security and the economic security of the state. For example, the budget of, say, next financial year 2021, and you want to have a copy of budget document before the budget is produced. Hello?
Yes.
Am I audible, visible, both?
Yes, yes.
Okay. Suddenly I was, seeing somebody's screen there. So anyway, so the finance security, the Ministry of Finance can definitely deny this information, saying that laughable stock. We have so far not produced this before the Parliament, and you are seeking through RTI application that give me a copy of the budget. So they will apply 2-3 principles. First and foremost was the economic security of the state. That's the first principle. Second principle is that disclosure of that information is going to make him accountable to the Parliament. So those are the exemption clause. So legitimately, public authority can exempt certain information. And first was, as I said, the national security. Second information is any information which may result into the contempt of the court or the tribunal that need not necessarily be disclosed. But it is very important to know that necessarily only because a matter is pending before a court of law, it does not become an express forbidden by the court of law. And therefore, all legitimate cases cannot be denied on this ground that disclosure of this information would result into, contempt of the case. And then you also have the Parliament's, if the breach of privileges of the Parliament comes into picture, that also you need not disclose. But there is another challenge. Are the privileges of the parliamentarian in this country codified? That's a question. How would you decide what actually makes the privileges? That's a challenge. So, and then
not a challenge. They are not defined. They are there they are constitutional rights.
No, that's what I said, Mr. Chadha. I said that since it is not codified, a poor fellow who is
various interpretations are there, and judgments are there through which we can interpret.
Huzure Ali, a public information officer sitting in one of the scientific organization, he is not exposed to these necessities of the law. So I'm saying that these are the challenges. I did not say that these are, of course, people are passing judgments in this regard. And then obviously the commercial confidence you need not disclose. For example, Ministry of Railways need not disclose to one of the transporters as to what are the principles that they are taking up to decide how should they fix their freight on Mumbai-Delhi corridors and so on and so forth. And then you also have information which you have shared with a public authority in a fiduciary capacity. A very classical judgment passed by Honorable Mr. Justice Sanjeev Khanna, as then he was Justice of High Court. And he had defined so beautifully in this asset disclosure case of Supreme Court of India as to what is the fiduciary. Is the relationship between doctors and the patient, and the lawyers and the client, the parents and the ward. And sometimes I also give another example The classical example, the relationship between the boyfriend, the girlfriend, wife and husband is the classical fiduciary examples. And any information which is held by a public authority in the fiduciary need not be disclosed. And then you have also, if you have received something from foreign government, you need not disclose. And then papers relating to the Parliament, Council of Ministers, you need not disclose. And impede the process of investigation or prosecution of offenders, you need not disclose. And the biggest challenge is the personal information, disclosure of which infringes into the privacy of a person. So the two words have been used. The legitimate intent is that all personal information does not become private, mind it, but all private information is essentially a personal information. So all personal information need not be denied, but all private information must be denied unless the larger public interest demands disclosure of the personal protection. And you know what? There is a proviso under this law, under this section, which says that provided any such information cannot be denied, which cannot be denied to the member of parliament, cannot be denied to a common man of this country. Look at the elevation of a common man from him being a common man to be equated with the parliamentarians through a legislation. However, the reach of this proviso is only limited to this provision, and it says that therefore you ask a question: is there any class of information which can be denied to the parliament? And the answer is yes. Any information which relates to my privacy, as to after 6 o'clock what Mr. Pandey, even if he is a part of the public institution, does is beyond the reach of anybody else, except perhaps there are other corroborative evidences to share this information. So the privacy of information is a very critical element of this law, and this is going to create throw a big challenge before us as to how should you manage these privacy and the disclosure so that you make a balance of appropriate disclosure and maintaining the sensitive information so that there is no mismatch in the society. I hope, there were other things also?
Yeah, no, we'll take it forward from here. I picked a word as the last sentence was how much information should be given, how much, so as Supreme Court has rightly said, very nice word the Supreme Court has used, if I might say, that RTI should not become a surveillance tool. This is what Supreme Court has said. I remember while reading that judgment quite a long back, I think in November, and I had a elaborated show on that in Rajya Sabha TV on that. Anyways, so now I have got so many questions which from PM CARE to the recent amendment. PM CARE was asked by Mr. Rao, and many of them has Sahil Jain, and so many of them has asked it. And then there is one thing. So first of all, first question is about the recent amendments. What do you think that recent amendment? There was a lot of hue and cry, and so many people have asked that with the recent amendments which have taken place, now RTI quite a ineffective body. What you have to say on that? A very short answer.
These questions cannot be answered in a short paragraphs, but and also I'll have to make a proper balance. Let me answer this question again in my individual capacity, and that's my personal opinion. You have to keep on clarifying these, since I am having this. So my personal opinion is something that you see, the terms and conditions of the services of the information commissioners, which talks of the constitution of the Central Information Commission. The terms and conditions of the Central Information Commission is that their services were equated with chief election commissioners, which in turn are equivalent to the judge of a Supreme Court. And therefore, in the table of precedence, they are placed at what is called 9A, where the chief election commissioners are placed. Now that and they can only be removed in the earlier clause, they can only be removed through by the way of inquiry on the recommendations by the President of India to the Supreme Court and so on and so forth earlier. But now what has, so therefore, the government of the day would not have earlier so much of reach to the information commissioners. But through this amendment, if you go into the debate of that amendment, you would realize that one very important argument which was given in favor of this amendment was that since these information commissioners do not interpret so much so the law as the honorable judges does from the constitutional perspective, so therefore equating them with the judges appears to be slightly giving them more weightage. So and since this is a very this is not going to the orders of the commissions are not going to give so much of conflict resolution, except perhaps passage of certain class of information, they should become part of the sort of government. And having said so, now what will happen? Their terms have been kept at 3 years. Their perks have been limited to certain equivalent to the cabinet secretary or like that. So it is now not the status, but it is now the salary. So if they have been equated with the salary pedestrian, I believe there appears to be only the problem of their terms and conditions of their services. But insofar as I believe the interpretations of the law remains, I think it has remained untouched by this amendment. So they have only amended the terms and conditions of the appointment of the Information Commission.
I put a very, straightforward question to you. Do you think that these amendments will give the government, power to influence these people, the RTI officers? Let it be your personal reply, not reply of any government.
Mr. Chadha,
we are paying the government. Somebody is paying the salary. Somebody is managing the roster. Somebody is managing everything. Do you think that somebody has influence on the RTI people? That's what is my question. I don't want you to correlate that with judges. Let us answer yes or no. It might be yes or no. Yes. To me, I will reply later on.
No, you can certainly reply whatever you wish to, but these questions cannot be a multiple choice question. But if you ask my personal opinion, yes, I believe that, as I said, consequent upon this amendment, no provisions of the law has been tweaked. Correct. It is only the positioning of the Information Commissioner which has been given a different treatment. That's it. So logically speaking, the role and responsibility of information commissioners should not be affected by any changes in the amendment of the law. But as I said, the perception, the powers and other things are dependent on the perception. So perceptive changes may have taken place, but as I believe, the essence of the change has not taken place.
Let me clarify for my listeners here today. I also give my perspective to this, and I will give a very recent example also. Now, yes, Pankaj is very correct as far as the working, as far as the powers, as far as the decision making, as far as the area of territorial jurisdiction, etc., is concerned. There is no change in it. But as he's very rightly said that yes, if the controlling authority is, which we should presume, because otherwise, if you start doubting intention of each and everything, then nothing is what we will get out of it. So if we answer it in theoretical terms, yes, it has not made any change. But I give you one example here. What has happened? Wasn't it, I'm taking something very, very imaginative I'm talking here. what we have seen the other day, a criminal, in a terrorist, and a person who should be hanged was killed. Don't you think it was a of my democracy? That's what I'm being very, very harsh, very, very. I don't think for what purpose then our legal system is. So I'm not correlating it, but something which just expressed it. Pankaj is, don't correlate the two things, but yes, we have to see that as a very old saying in the law is that justice should not be should be also be seemingly being done. So, if at all something is giving you an apprehension, if at all something is raising any question, one must immediately rectify it. That's what is my way of looking into it. Now, I would like you to answer Mr. Rao's and so many other, my own, Shubhangi Sharma has also asked this, and so many other people are very curious to ask about PM care. What you have to say that Mr. Rao has just, he's giving a smile. So what do you think? What is your answer to why RTI is not applicable on PM care fund? Sahil is also there.
See, when the questions are asked with a great smile, answers are already there. Let me catch those answers.
Yeah, please.
You see, let me go back to the PMNRF first. In 2009 or 10, if I'm not wrong, RTI applications were filed and the matter was brought before the Commission for adjudication, and the Central Commission declared them a public authority. So PMNRF, National Relief Fund, is a public authority, and they had appointed their CPIO and other things. Now, since it has so far not been put to the test of the law, so no judgment has come because it's a recent creation. Somebody has to raise this issue. Let's go back to a small example I give you is that all sports association until 2012 in this country were not a public authority. So we directed the Ministry of Sports and Youth Affairs saying that, look, and there were 70 sports associations. So all of the sports association, if you want us to declare them a public authority, then we would not like to do that, and we will declare you as a public authority for each one of them. And you imagine if RTA application keeps on coming to you, it will be a difficult propagation for you to respond.
And that is the reason that National Sports Code they had made in 2011. That is
one of the important, yes. And also the second thing is that the judgment of BCCI, Board of Cricket Control in India, we had declared them a public authority. It was initially stayed by Honorable High Court of Madras. But later on, the judgment was passed saying that, look, mind it one thing. It is not necessarily that you must be directly or indirectly funded by the government to become a public authority. If you are representing India, this itself per se makes you a public authority. So what kind of structure of functioning of this PM care is there? And if this issue is raised, it is something to be decided thereafter. But I would only like to apprise you that since PMNRF was on the same principle declared as public authority.
So very true. That is very true that if till the time this question doesn't come in front of the decision makers, or as I would say the persons who declare what law is, that is our judiciary, till the time how can anybody can guess around it? I totally agree with it. Mr. Rao is writing to me that I was more on the appointment committee of the cabinet headed by the PM to most government bodies. No, what do you say about it?
No, I didn't get this question.
Mr. Rao, can you ask, please? You are free to ask now. Mute and please ask. Your mic is not on. Yes, now it is on.
Yeah, good evening, everybody. Thanks for this opportunity. It's lovely listening to you all. I'm basically, see, the Prime Minister is one of, there's a committee called the Appointments Committee for Cabinet that decides most of the directors in public sector undertakings or government headed over the rank of Joint Secretary and above is decided by this committee. Earlier, what used to happen is the person selected, the ministry to which he was working earlier was a part of the committee. Amendments were made where that ministry has been taken off, and now it is not a transparent process. You see, when the person is appointed, we look at in such high bodies and high level. The basic thing is integrity and moral turpitude. These are two issues that concern me, nothing beyond that. And I have noticed of late that many people who have pending cases of moral turpitude have been appointed by them, and we are not able to question the government on this. And it doesn't come under the RTI. That is the saddest part.
No, let me sir respond to this.
Yeah.
It is in my humble submission, it is not true that it does not come under RTI. Let me remind you of a case in 2011 which was raised through RTI, none other than Mr. Arvind Kejriwal, as he was the then. And he filed RTI application with Cabinet Secretariat, Department of Personnel and Training, as also with the Prime Minister's office, as to how does empanelment in the government of India does. And as you rightly pointed out, empanelment has to be done through the ACC. And the public authority, in fact, they denied the information that there is nothing available on record and so on and so forth. And the matter has been brought before the commission, and commission had declared that this document has to be made public. It is again a case for us to wait and watch. Is that High Court had initially stayed this, and the matter was remanded back to the commission as early as in 2014 to hear this matter. Yet again, as was needs to be disclosed, this needs to be declared. Also, similarly, in 2009 or perhaps 2008, when the foreign secretary was appointed by superseding almost 25 Indian Foreign Service officers. At that point of time, also the same lady who resigned, who was the commissioner, High Commissioner of Bangladesh, she had filed herself an RTI application, and that matter has also been stayed by the court. So it is not a fact that it does not come under RTI. Anything under this sun is under RTI unless it is denied so far. So it's not that these matters have not been agitated. They have been agitated, but it has so far not passed through the scrutiny of the superior courts. So you only have to keep on watching as to what is the judgment which is coming. Insofar as commission is concerned, they have said it, you have to declare, because that's a important element of calling yourself a transparent way of decision making.
One question which came from Mr. Inderpal, who is from MEPSC. He has asked whether a company which is 100% funded by private individual, can that be covered? Can you can say that it is a public authority? Or what I feel is, as the very nice way of saying is that on the face of it, it is not covered. It is not a public authority. And but yes, there are other regulators, as I can give you the examples also, like we have for banks, Pankaj has said banks, we have banking ombudsman under RBI. Then we have for the insurance, all the insurance companies, all the insurance players, they are covered. And for them, there are various banking ombudsmen are there, one. And second body which also regulates them is IRDA, as we have discussed so many times. So I feel that is there. Now, another question which is also asked here is, if a private company been taken over by, it's a hypothetical question, but it's a good question. If a private company taken over by the government, and then somebody can ask about the question pertaining to that period when it was a private company. What is your
Yeah.
answer?
The first one is that whether it is 100% funded by a private body, is it a public authority? Prima facie, it appears that it is not. But let me tell you that the litmus test of declaring a public authority is not only limited to the financing pattern, but is also the pattern of its discharging the public function.
Yes.
If it is a private body, but it is discharging the public function, it can indeed remain a public authority, even though there are no fundings. And that has been, in fact, declared by the superior courts in the discoms matter itself. Even though they are public authorities minded, but they are discharging public function. Each of the decisions.
My correlation, which I want to mention here for all my law students who are there, so many law students are there. As we say, what is state is defined in section in Article 12. So there, this ambit of state is expanded day by day. Similarly, the ambit expanded by various judgments passed by CIC, various high courts, and that's how the ambit of the bodies which are covered under the ambit of RTI is also expanded. And now one more thing I thought you will be talking about is a new dimension to the RTI, which is online RTI. That's also has I feel you must spend at least 2 minutes on that as well.
Yeah, you see, way back in 2012-13 itself, Department of Personnel and Training, which is the nodal ministry for the government, they have declared, in fact, they have made one portal in which you can just go and file an RTI application by choosing from drop-down boxes as to what public authority you want to file an application with, and you make a payment only through these three modes. And also through the online transaction, and you can get the answer through the portal itself, or if you have given some email address, you will get the response from the email also. So this is a very good beginning, and I mean, this needs to be. And what has happened thereafter is that lots of RTA applications which are coming there, the responses are also available in public domain. So what may happen is that one of the public authorities which has already declared something, the other public authorities, similar questions, if they are not willing to do, they may get influenced by these responses, and they may also get themselves changed accordingly because they know that another public authority has already declared. So it is also quite convenient for the young students or younger generation people to try their hands at, lay their hands at, and understand in true sense how does governance in this country work. Achha, Mr. Chadha, the last question which you had said, that if a private company is overtaken by another the government body, and there if somebody wanted to file RTI application, if you wanted to get that information from that period, that's interesting question. And I think let's go step by step, deconstruct it. First of all, the moment it is taken over by a public body, it becomes a public authority. Now, I will file an RTA application wanting to know information about, say, 10 years back or 20 years back. Let's go back to the law. You know what it says? The problem is, if you hold the information, and if it is 50 years old, at that point of time, you have to declare. Because alternatively, what you can do is that while you are merging with the public body, please decide and declare yourself that these documents which need not be transferred to the public authority shall remain out of the scope of the RTI application. And
I think we have to be shorter in our replies. I know you have always very enthusiastic about it. I know that very well. But now, because there are so many questions, I don't want to miss these questions. There's one question from Bobby Envy. What they say that when the PIO fails to reply within the stipulated time period, the subsequently the appellant authority too happens to fail resolving the issue. The applicant is made to approach the CIC, and the issue is dragged on, causing an inordinate delay. Now, my question is, can't the concerned authority frame rules to hold the head of the department of a government organization responsible for non-compliance of the first appellant authority and his officer have failed to RTI and before the appellant is made to approach SIC or CIC, resulting in inordinate delay? Kindly answer the question. Now he's talking about the fixing of the liability. Now the section 20, I had said, I think there is a specific provision of penalty if within 30 days if the public authority doesn't reply. So I'm just giving you smaller feedback, and to the extent of 25,000 fine can be. Pankaj, you threw a light on it.
Yeah. You see, if the CPIO does not respond to you within 30 days, you should first file an appeal, or simultaneously you can also file a complaint before the commission. So the moment you file an appeal before the appellate authority cannot fine the CPIO. But if you file a complaint before the Central Commission at the same time, because he has refused this information to you, he will be penalized straightforward to 25,000. And the rate at which they are penalized is 250 rupees per day, not exceeding 25,000. Now your question is, if we go to the commission, it becomes an inordinate delay. Yes, I agree with this, but that's the general principle of the scheme of the RTI Act. And the time limits have been prescribed for the CPIO to respond within 30 days, another 30 days for the appellate authority, and 15 more days to be written justification for. So 45 days for this, another 90 days, within 90 days you can file an appeal before the commission. But unless the commission address this issue, I think nothing can happen. You have to wait and watch. That's the scheme of things. Once they decide,
another thing,
once they decide, you may say that, look, only penalty is not sufficient. I also want myself to be compensated because of for this inordinate delay. I lost something. So there is a provision in this law.
That loss, and then if you are able to successfully prove that loss, you can get that as well. One other question, which is very, very, so many people have asked it, including Bobby and so many of them. They have asked about what is the status of a lawyer. Can a lawyer appear before the CIC and state, because these authorities are, it has been seen that they say that no, the person who's asking, who's demanding for the information should appear, not the lawyer. What is the
rule? The rule position in this is, it says that any person can appear who need not necessarily be a lawyer. That itself clarifies
that lawyers
may appear. Yes, let me share with you.
Of example, I just wanted to give. I'm sorry. CIC here in Delhi. So that's all. Now so that shows, and I appeared not for my case, but for my client's case with wakalatnama or with authority power of attorney. Now Pankaj will clarify it more.
I tell you that from public authority side, when the Supreme Court appear before the commission, I have never seen their registrar speaking their mouth. It is through their lawyers that they spoke. The UPSC always appeared before us through their lawyers. I give you another example of this GMOs, when this Department of Biotechnology, GMOs, where Prashant Bhushan appeared 100 times on behalf of many people, including Arvind Kejriwal ji. So lawyers are not barred.
Okay. Now there is this question by Mr. Dhananjay Malik. it is true that one can file a RTI through an email. What be what could be the way to meet requirement of rupees 10 while filing the RTI through email? Also, who can file RTI on behalf of the illiterate person in a way that PIO could not take a plea and state him a third party under section 81J? बताइए आप, तब तक मैं और क्वेश्चन निकाल रहा हूँ.
Let me correct it. Third party is propounded under section 11, not under 81J. 81J is only about privacy clause.
All
But
right.
having said this, let me go back to the question what you have said. Very important question. In such a situation, if a person who is a illiterate person, he does not know how to write, so he is seeking your assistance. So what he should do is that a paper he writes that I hereby authorize this person on my behalf to ask a question, and put a thumb impression. You scan it and email it to him, saying that I am only becoming a platform for this fellow to seek this question. His questions are his. So your email would be there and his questions would be there. And thereafter, you will say that I'm paying this money and I'm sending it through either through post, or I'm sending it through postal order. Alternatively, what you do, you go to the portal of which I said, because in the portal there is a provision of online transfer of the money. So that you can do and take it from him. In lot of smaller places, there is a CSC centers, common service centers. There people go, गांव का एक आदमी जाता है, उसे 50 रुपए दे देता है, and this fellow does it through his own account. So similarly can be done through here.
Now, Saurav Gupta says that online second appeal was returned with the remark, make index and attach relevant papers. Please confirm if online second appeal can be filed offline only. What is this question?
No. When I was there in 2011 itself, we had prepared this online mode of filing second appeal before us, and this was awarded to us as a first e-governance award in Hyderabad. It is still there, so you can go onto the website of the CIC, and you can through there you can file your second appeal through online matter itself. Yes, insofar as the format of online appeal is concerned, that of course you will have to comply with the formats as prescribed by the appropriate government.
My own Lakshmi is asking this question now. Lakshmi is saying that there is one more question. Can spending of districts for COVID be questioned on RTI?
Of course. As I said, you can ask anything under this sun. In the Hindi literature, there is a very famous poet which says, "Mujhe chand chahiye." So if you want moon, you ask it. It's a different story.
It will be rejected.
It's a
maximum.
It's a different.
What will happen? Maximum, it will be rejected.
It's a different story altogether. They may say that they may. No.
I'm sorry.
They will not say hum nahi denge. They may say that this information is not available with you. But what you are raising is a very pertinent question. And this is what I wanted today to tell you, apart from the provisions of the law. As a common man of the country, we should be aware, and we should not always expect the government or its governmentalities to keep on, solving the issues. Let's.
One very important thing just came to my mind. I am asking for, let's say, some question on RTI, some information I'm seeking, and the best how we see many a time that the public authorities, I am asking for ABC, they are replying XYZ. You are asking for something, they are giving irrelevant documents and they are saying, please file another 420 rupees, and they will give you something which has nothing to do with your question. So what is that? This is one of the problem which is faced by our common citizens. What do you think?
As I said few minutes back, is that it's a strategy, and there is nothing wrong with this strategy.
Why?
So if this kind of answers you receive, sit with that answer, find out the loopholes, and follow it up with yet another RTI application. And if you series of RTI application will certainly lead you to certain conclusive end. As I said, you need to have a patience, and nothing better than a lawyer knows about the value of a patience.
So that's what in a very, in a very rude term, now I'll speak that in various time, it happens in corporate world, they start playing email. So RTI will start playing. That means they will start giving you answers. Okay, now इस बार ये ले लो, अगली बार ये ले लीजिए, उससे बाद. This is happening, my dear friend. So we need to have this thing. We need to have. If I have asked for A, I should get A. I should not get Y. I'm asking you something, you are not replying that. As happens, we have seen it.
No, Mr. Sanjay, this is, you see, had this been so simple, you would not have required RTI. So it is. You should expect this kind of intricacies.
I would say that because you are a very good public speaker and you've been authorized by the government of India to speak on RTI. So I would request, you have given us so many challenges. You said that this is a challenge. So add one more challenge in your list, that this is one challenge, that our RTI officers, our public authorities are not giving the right information quite a time, many a time.
Yeah.
This is another challenge.
That indeed is a challenge.
Mr. Rao is giving a nice smile to this.
And that is happening because of the fact that at many places the record management practices are in shambles.
But
and that's hardly...
no doubt about it, that this is a big milestone in making my democracy, making the system of our country a little stronger. So it's a big milestone. So now I would like, because I could read very few of the questions if anybody wants to ask anything, though we have, the best part I wanted to tell you that look at the people are still intact. We have crossed our limit. So nice. Pankaj ji is always, जो कान नहीं है इनका मान ही नहीं रहे कि अब रुक जाएं आप. But everything has a limit. So one last question, if anybody wants to ask, we can take, and thereafter, we will certainly. I want a promise from you that we will have another session soon. It was an excellent. As I was saying to my listeners, that it would be a good session. We'll have another session soon, and probably one question has come. Please ask him if we want to get the information about how much health budget is given to each district and how much they have spent it, along with the documents of both in a single RTI. Then what is the competent authority and against which body should the RTI be? This is a very brilliant student of whom I have interacted. She is from Amity Law School, Yashika Manchanda. She had very recently, Kal Ki Baat Hai, I have read her one of very nice articles she has written on on what are the possibilities of FIR and how it is a right and it is a subsequent duty on the part of. Very nice, Yashika, and we are very proud of you, beta. Sir.
Yes, it can be asked from the Department of Health, because you are asking it for each of the districts. So it can be asked from the public information officers of the Department of Health and Family Welfare. If it is a state government of a particular state, if it is a central government, it is since you are talking of a district, so essentially it is a state government. So you can file an RTI, PIO, state government, Ministry of Health and Family Welfare. They call it, Department of Health and Family Welfare. And then you ask one question, number one, prepare this thing, please provide the budgetary provisions for the last year in this head. and number two, district wise, and number two, the expenditure statement as on say March 2020 by each of the states, each of the districts accordingly. And a short and sweet question, I'm sure will be responded, because this document is a public document.
An applicant in his complaint requests the commission to impose penalty on a public information officer for not transferring his application before the appropriate PIO under section 6(3) of an act. Is it valid? This is a question of Harshil Munjal.
Let me go back to this. So far, 6(3), transferring an application to an appropriate authority, failure of which imposition of penalty, to my mind, is not justified for the following reasons. A, yes, it is indeed a fact that PIO is a single window system of a public authority. And 6(3) is invoked for transferring this to another public authority, the functioning of which he is not necessarily supposed to know. Mind it, he is just a public information officer. He is not a demigod who would know that everywhere what is happening. So, yes, he may be defaulted for not transferring it amongst his own departments. But to another public authority, he may not even know as to which public authority will hold this information. And he will be well within his rights to say, since you have filed this application to me, I as a public authority do not hold this information, and therefore I am disposing it off only on this account. You are hereby advised to file it with the appropriate public authority, which you have to find out. He is not obliged to find out as to which public authority will hold this information.
One question Bobby is asking, this is the last question for today. What is the limitation? He's saying, is there any limitation of number of questions in one application?
No, there is no bar on how many questions can you ask under one application by filing 10 rupees. I give you an example. In UPSC, somebody filed an RTI application which had 678 pages and around equal number of questions. Each questions were having A, B, C, D. But then, of course, you have no bar in as many questions as you want. But do you think if you keep on sending these kind of questions to a public information officer, the the relevance of the RTI application will be lost and you will hardly get any response? But theoretically speaking, there is no bar as to how many number of questions. However, let me apprise you of the DOPT has made a rule which says that ordinarily an RTI application should not have more than 500 words, excluding the salutations. However, this cannot be made as a basis of rejection. Again, it is neither here nor there. But in some of the state governments, they have restricted the number of words. For example, Karnataka, 150 words, not beyond that you can file in one RTI application. But in the central government public authorities, there are no restrictions on the word. So a sigh of relief on that account.
Thank you very much, Pankaj. It was excellent, and a lot of things I have also learned today from you. As every day, the learning is a process which continuously on, and I'm also thankful to KVJ Rao Sahab. He has given us full time since the beginning and till end. He is there. We are honored to have you, sir, and many other people. I would say from MESBC, Mr. Indrapal was also there, and many of my own dear students are there. And now I would request Rini to please have a vote of thanks for all of this.
Sure, sir. So I take this opportunity to propose the vote of thanks. Thank you, sir, for the extremely enriching session on RTI. Indeed, RTI is a subject which arouses immense curiosity in law students and the general public alike. So I sincerely thank you for sparing time from your hectic schedule for us. I'd also like to thank Mr. Sanjay Chadha for bringing us this wonderful opportunity. Also, our promoting partners, Legal Tribe, Briefcased, and Wikipedia.com. Thank you so much. And thank you to Pallavi and Aisha for all your support. Last but not the least, our audiences on Zoom, Facebook, and YouTube. Thanks, everyone. Have a great day.
Thank you very much. You are always very sweet. And as I say, and a special thanks I want to do to Lakshmi, Pallavi, and all my three partners. As I always say, they are doing wonderful work. All the three, I am wishing you all the best and best of luck. Please grow as much as you can and keep asking, as Pankaj ji has said, you will get the right reply. You can ask even noon, but it's very nice of all of you. Thank you very much. Thank you very much, Pankaj ji,
Thank you.
for
Thank you
taking
so
out
very much.
time. Thank you, Pallavi. Thank you, Lakshmi, Shobhangi, everybody. Inderji has come. I have just thank you, sir. Thank you very much, Inderpal ji. You have come and joined and you have asked the question. Thank you very much. It's always, an honor when such a people like Mr. Rao, Mr. Inderpal, they have joined us. So I feel very proud sometimes that yes, we are on the right track. And it is knowledge which we are sharing. And I'm very proud of these students, Pankaj. I want to say that all of them are so knowledgeable and so much they are interacting with us. And it's nice way we are doing. And next, we are going to have a lot of such sessions. I'm promising it to all of you. Thank you very much once again.
Thank you. Bye-bye.
Thank you. Bye. So now I will leave the session. Okay. Thank you. It was nice. Very nice. Thank you, whomsoever I can see. Google link आप भेजेंगे. That is separate thing. ठीक है. Thank you. Bye bye. Bye.
Thank you, sir.
Bye, sir.
Bye.
The Google
Bye.
form link will be circulated soon on all WhatsApp groups
Bye.
and our social media handles as well.
Yeah,
So
yeah,
please check those out.
yeah. Thank you. Thank
Thank
you.
you, sir.
Thank you, sir. Thank you.
Bye bye.
Bye, sir.
Thank you, sir. Bye, sir.